So good morning, good afternoon, assalamu alaikum and namaste. A very warm welcome to all our participants. Thank you for joining us for this very important session on land and property taxes in Saudi Arabia. Well, real estate, I mean, a topic generally very close to all our hearts. We see real estate as a safe investment bet. We see real estate as a store of value. And hence, we decided let's pick real estate as one of our key first topics for this webinar. And we, being a pure tax firm, we had to do real estate taxes to start with. As a quick introduction, my name is Manish Bansal. I'm a tax partner for Dhruva in Saudi Arabia. Been in the region for almost 7 years now. Been doing indirect taxes for last 17 odd years. And really happy to be presenting before you. And I'm joined by my colleague, Nikhil Agarwal, who is a senior manager and has spent quite substantial time in Saudi Arabia as well, doing VAT in the region. So, yeah, I mean, we have an action-packed agenda. We can move to the next slide. We have an action-packed agenda. In this session, we'll demystify some of the key issues surrounding VAT, real estate transaction tax, and white land taxes in Saudi Arabia, especially the recent amendments which have been announced by the government. Especially on white land tax, I would say that this has been a public demand from me because people have reached out to me saying, Manish, you do a lot of real estate taxes, especially RETT. So why don't you do a webinar on white land tax as well? So again, I would say that this is more of a public demand. I had to do a lot of research on white land taxes because that's not one of my areas of, say, core specialty. But yeah, I've tried to incorporate as much as clarification as possible, and I hope this is something you would find really insightful. Next slide. So again, real estate and especially real estate in Saudi Arabia, we all know how important real estate is for Saudi Arabia, especially under the KSA Vision 2030. It's one of the cornerstones of Saudi Arabia's shift from oil dependency, and it has planned a targeted contribution of Saudi Riyal 316 billion to the GDP by 2030. It supports the growth of non-oil sectors such as tourism, logistics, entertainment, everything you talk about. If you're building hotels, you are building real estate. If you're building hospitals, you are building real estate. If you're building logistic parks, you are building real estate. So real estate, of course, is a cornerstone. And we all have heard about the giga projects, the like of Qiddiya, Roshan. We have the King Salman Park right in the center of Riyadh. We have the King Salman Airport. So yeah, in summary, it's redefining the urban landscape of Saudi Arabia. And recently, there have been quite a few changes which have been announced in this sector. And that's where we thought it is very important to do a webinar on this topic, especially first and foremost, it's a foreign ownership law. So yeah, that's a good news. The expats can now buy properties in designated areas in Saudi Arabia, which was not the case earlier. So this kind of boosts liquidity and international investor participation for the kingdom. Whiteland tax, we'll be talking about that a lot in this webinar. Whiteland tax has been substantially revamped, as you will see in the course of this webinar. And then we have the real estate transaction tax, which we finally have a new law in place and some substantial changes. And also a 5-year rent freeze in Saudi Arabia, in Riyadh especially, not in other cities, just in Riyadh, which is aimed at stabilizing costs and enhancing affordability. Next slide. Next slide. Okay, so there you go. One of my favorite topics, real estate transaction tax. We'll refer to it as RETT during the course of this webinar. So RETT, as we know, as a quick background, was introduced in October 2020 by the royal decree, and then we had a set of implementing regulations. But yeah, we never had a RETT law, so to say. Now, on 24th of March, the new regulations were issued, and the new RETT law was also published in October 2024, which had 180 days to be implemented. So ultimately, the new RETT law and the new regulations come effect from 9th of April 2025. With this, the erstwhile implementing regulations has been rescinded, and now we have a new set of RETT law and the new regulations which have taken place. So during the course of next 20 minutes or so, I'll take you through some of the key changes which have been brought in and some of the differences which we see from the previous regime and the new regime which has now been introduced. Next slide. Next slide, please. Okay, so we begin with the first one. So some of the definitions have been amended and some of them have been quite substantive and I would say business-friendly changes which have come up. First in line is the definition of real estate company, which has been amended. Now, earlier the definition was that uh, a real estate company is a company whose fixed real estate assets are more than 50% of their total assets or capital. That's it. That was the definition. But now the definition has been substantially narrowed, generally to cover only the core real estate sector activities. So now the definition is 50% of the real estate assets is more than the total assets of the company only. So the comparison to the capital has been removed, number one. And number two is only those real estate will be considered which are used for generating revenue by way of selling or leasing. So that's the core real estate activity. So what used to happen in my practical experience, companies such as hospitals, factories, mines, they used to ask this question to me. Look, Manish, we are not a real estate. We are not into real estate business, but still we qualify as a real estate company. This seems a bit weird. So yeah, I think this is a very substantial relief which has been provided to such entities. So going forward, only those companies which are into the core real estate business will be qualifying as real estate company. Now again, an important clarification here is the definition of real estate company is only relevant where the shares of a company are transferred. Otherwise, if any company is transferring a physical real estate as such, so if a hospital transfers the hospital building, it will be subject to RETT. But if the shares of that hospital owning company are being transferred, then potentially under the new regime, the RETT may not apply. So that's a relief, I would say. Now, again, some important changes to the definition of real estate as well. Now, definition of real estate has been slightly widened, I would say, to include some properties, some movable properties, which are intended for permanent use, which are placed in a real estate property and intended for permanent use. Now, this is a slightly ambiguous provision, I would say. I mean, potentially, how I see it is some of the entities like hotels, which have furniture and fixtures, etc., permanently installed into the hotel building, or say power plant, which might have some movable machinery incorporated. Those are the sectors which might potentially be impacted due to this amendment. Next slide, please. Next is some welcome clarifications, I would say, around the share transfers and the share issuance. So ZATCA has tried to introduce a de minimis threshold for share transfers. In the earlier regime, there was no de minimis threshold. So any transfer of shares, even 1%, was subject to RETT. But now 30% threshold has been introduced, which says that, yeah, if the RETT will apply only where the share transfers exceed 30% of the total capital. But now 30% can be done through one single transaction or a series of linked transaction within a period of 3 years. So this is more of an anti-avoidance rules. So that the people do not artificially split the transactions into multiple transactions. But the intention was to transfer more than 30% in one go. So I think this is where I believe documentation will become really important to substantiate that, yes, there was no linkage existing, and if there was something which was bona fide, then appropriate documentations are maintained accordingly. Similarly, for real estate investment funds as well, it has been clarified that the threshold will be 50%. So this is even higher. And then 50% transfer can be made through a single transaction or a series of transactions. So similar anti-avoidance rules have been introduced for funds as well as for the company's transfer of shares or units, as the case may be. Now, a question which was an ambiguity which was there, in the earlier regime was transfer of shares were subject to RETT, but were the issuance of shares also subject to RETT? And mind you, just to clarify, when we talk about transfer of shares or issuance of shares, it is in the context of a company qualifying as a real estate company only. So that is something which we need to be keeping in mind. So yes, the question which used to be asked was whether issuance is also subject to RETT. Now this ambiguity has been laid to rest. Yes, in principle, by default, issuance of shares in a real estate company will also be subject to RETT. However, there have been a lot of reliefs granted, which says that if the shares are issued to an existing shareholders of the company, then RETT will not apply if the ownership percentage does not change. So for example, if me and Nikhil are the two shareholders in a company, and new shares are issued to both of us. We held the shares 60-40, and even after the new issuance of shares, our shareholding still remains 60-40. In that case, no RETT will apply on the issuance of new shares. But if the shares are issued to the new shareholders, then RETT will not apply if the existing shareholders hold their shares for more than 5 years after the capital increase. So in the same example, if me and Nikhil hold 60-40, and then a new shareholder comes in to the company, then if me and Nikhil hold our shares for 5 years, then RETT will not apply. So that's the clarification. Yeah, but and then there are few open questions here, I would say, which might come up, is that who is to pay the RETT? If RETT is to be applicable, who will pay the RETT? Whether it will be the um, receiver or the company who is issuing the shares who will pay RETT. So that's an open question which still needs to be answered. Now, one of the important things is, yes, clear differentiation has been made between share issuance and share transfer, and RETT treatment has been clarified now on issuance of shares, which was a big point of contention in the earlier regime. Also, one important thing is some clarification has also been provided on the time of supply in case of share transfers. Now, generally what used to happen, and this again is a practical issue which I have seen personally a lot happening, is generally the share transfers are subject to conditions precedent that share transfers will actually be effected while the share transfer agreement may be signed on a particular date, but the actual share transfers will be effected once all the condition precedents are satisfied. Now, a question used to come up is, when is the RETT due? Was it on the date of signing of the agreement or when the actual share transfers happen? Now it has been clarified that when an unconditional agreement is signed, only then can the RETT due date be applicable. So, which means that once all the condition precedents are satisfied, only then RETT becomes due and not on the signing of the contract. Next slide. Okay, some good news again. Some new exemptions have been introduced as well. Exemptions in relation to mergers and acquisition. Now, this is a new exemption and an exemption which is certainly being welcomed by the industry. So, share-based mergers and acquisitions are exempt, which means that the consideration for share transfers or consideration for merger and acquisition transactions are being paid through shares only. Now, there is a specific definition for what constitutes a merger and what constitutes an acquisition. But in principle, this is where you acquire a company, or can we go back to the next slide, please? Yeah. When you acquire shares of a company or when we acquire the assets and you pay by way of shares, that transfer is exempt. Any consideration paid in cash or in kind uh, is not exempted. 5 years clawback period applies. Next one, grouping exemption. So this is a red group wherein in transfers between 100% owned entities are generally exempt. Now, this is not a new exemption, but I thought it's important to highlight this exemption because there has been a slight change in how this exemption has been worded. So now it says that transfers between entities where both transferor and transferee are owned by the same person is exempt. Um, so the change here is the word use of the word person as opposed to persons. So singular as opposed to plural. And this is something which was there in the earlier regulations. When the earlier regulations were issued, it was a singular person, but then it was subsequently amended to persons, a plural. So a group of people can own two companies commonly, and those transactions will be exempt. But yeah, right now the law says persons, and this is something we expect that should be clarified um, in due course. Next in line, off-plan sales, again, not a new exemption. Transfer of land for an off-plan sales project is exempt, which was the case earlier as well. This is subject to two conditions: that the buyer has a WAFI license, an off-plan license, and the land is also designated for an off-plan sales project. Now, the difficulty used to arise is the designation of the land as an off-plan property was generally difficult because, yeah, the buyer did not have the title to the land, and before he had the title to the land, he could not have designated the property for off-plan sales. So this was a practical what comes first sort of an issue that developers were facing. So now this has been relaxed, I would say, with giving a 90-day window to have the after the land transfers for the buyer to get the off-plan sales designation, but a bank guarantee is required to avail this exemption. So an important change, a welcome change. We are yet to see the effects of this change, and one of the things that we need to see practically is whether 90 days timeline is enough to get the designation from the WAPI committee for the off-plan sales project. Next slide, please. Well, wood contracts, yeah. Although this was already clarified in the earlier set of regulations also, but the new regulations and the law have been introduced on the same lines. Yes, RET is applicable on boot contracts. So this ambiguity or kind of question has been laid to rest by the ZATCA. RET will apply on boot contracts. What constitutes a boot contract, where perhaps we can take a separate topic in itself on that one. But yeah, RET is applicable. The transaction dates shall be the date of actual transfer of ownership to the transferee, and RET has to be paid within 30 days of the transaction date. So, and the actual transfer will be the transfer at the end of the concession, which is generally, typically, in my experience, 20, 25, or 30 years in Saudi Arabia. So that's when RET will be payable, and the valuation will be RET is payable at the time of value at the time of transfer. So which will be at the end as well, and which we expect to be the written down value of the asset being transferred. Now, one of the questions which I have in my mind is there a mechanism to determine the written down value of the future value of the assets 25 years down the line on today's date? Because that might be something which might be required by the financial advisors uh, to model the entire project uh, in the Excel sheet. So that's something which is an open question. So that's something which is yet to be seen as to how that will pan out, how the valuations will be kind of factored into the financial model as on the current date. Next slide. Next slide. Yeah, perhaps this is my last slide on some penalty reforms and buyer protection programs which have also been introduced. So the joint and several liability provisions have been relieved for the buyers. So in the earlier regulation, buyer was jointly and severally liable for any non-payment of RET liability, and it could have been for any reasons. If the seller did not pay, buyer was held liable. But now it has been relaxed for the buyers. It says that only where the buyer colluded and buyer was the reason for non-payment of tax is where buyer will be held responsible. Otherwise, he will to the extent he proves his bona fide, he will not be held jointly liable for any RETT exposure. So that's where I think, as a buyer, proper due diligence is a must. Proper documentation is must. You should have all the document trail, audit trail in order to substantiate your bona fide as a buyer. So that's something to be kept in mind. Penalties again have been reduced. Uh, Earlier it was 5% per month. It has been reduced to 2% with a cap of 50%. There was no cap earlier, mind you. So a good move, a welcome move again for the industry. But at the same time, that an additional 1% has been imposed if ZATCA identifies the additional tax due, which means if anything, any liability is identified during the audits, etc., then the penalty will be 3% and not 2%. So this again is a move towards voluntary disclosure, so that people disclose their liability fairly and truly. And this has been kind of a move which has been followed by the kingdom since the COVID time. The amnesty is a gift which keeps itself giving. It has been continuing since then, and the latest kind of spell of amnesty lasts up till 31st of December. So yeah, I think voluntary disclosure is something which has been really encouraged in the kingdom. Next slide. Next slide. Yeah, with that, I have completed my session on real estate transfer tax. I think, yeah, this was a quick snapshot of the changes, while there are certain finer prints as well, which of course I'm happy to have a chat. With this, I hand over the mic to my colleague Nikhil, who will take you through some of the changes which have happened in the white land tax regime over the recent past. So Nikhil, over to you.
Yeah, thank you, Manish, for covering the RETT part. Now, I am going to talk about the second most important aspect of this session, which is white land tax. But before we jump on to the details, just a quick introduction regarding myself. I am Nikhil Agarwal. I am a senior manager in Dhruva Saudi VAT team, and I am going to support my colleague Manish to run this session further. So can we move to the next slide, please? Yeah. So what is a white land tax? So the generally white tax land is an annual tax that is applied on undeveloped land in the Kingdom of Saudi Arabia that is designated for residential or commercial use within urban boundaries. White tax land, it's a recurring levy on an annual basis on the value of the land. And as you can see on this slide, the tax rate can range anything from 4.5%, and it can go up to 10% depending upon the priority zone of the land. So under the legislation, who all are covered? The white tax land applies to a natural or a legal person who owns the land which is subject to tax. So I'm going to talk about when a land is subject to tax in my subsequent discussion, but let's complete this one first. So in terms of the payment timeline, so normally the landowners are required to make the payment of tax within a period of 1 year. So they have a 1 year period either to pay the tax or to complete the construction or development of the land. And if they don't complete the construction within a period of 1 year, they are required to make the payment of tax within a period of that 1 year from the date of issuance of the invoice. Is there an exemption? Yes, there is an exemption. So state-owned properties, or if there are any sort of construction or development restrictions due to any obstacles, and the owner is not a party because of that restriction, then the exemption can be claimed. There are procedures which are given in the regulations. Following the procedures, the landowners can claim the exemptions. And now, at what value the tax will be applied? The valuation of the land will be done by the Ministry of Municipalities and Housing Committee, depending upon various factors, such as the location of the land, its market value, its topography, services attached to the land, such as whether basic services are available, such as roads, sewage, etc., and intended use of the land. So these are the some of the basic concepts of white land tax. Now let's move on to the next one. Yeah. So this is the entire development journey of the white tax land. So as you can as you all can see, so the white tax land was officially introduced on November 2015 as a part of Kingdom's Vision 2030 goals. The objective behind the introduction of white tax land was to regulate the real estate market, to reduce land hoarding and speculation, and to promote urban development and growth by making the land costly for the landowner if they hold vacant properties above a certain limit. So the law was introduced in November 2015, and then as you can see, the law was amended throughout from November 2015 up till March 25. So in October 2019, there was an amendment that allows the landowner an additional period to develop the land if the development has commenced. And then the major amendment was made in March 2025, wherein a directive was issued by the Saudi government to amend the white land fee system within a period of 6 years, 60 days. Let's move on to the next one. Yeah. Now, recently, on 12th of May 2025, the Saudi Council of Ministers has approved and made a number of significant changes to the legislation. And during the course of this webinar, we are going to provide an overview of the key amendments, what are the implications for the taxpayers, and practical consideration for the landowners. The amended law has now been renamed as White Land and Vacant Real Estate Tax Law. So previously, the law was named as white land tax only, meaning the tax was applicable only on white land. But now a new category has been introduced, vacant property. So this was the reason the name of the law has been amended from white land to White Land and Vacant Real Estate Tax. So the scope of the tax has been expanded to include all vacant properties that are unused building within the urban boundaries, in addition to the undeveloped land. So previously, the tax was applied only on undeveloped land that are designated for residential or commercial use. But now, under the amended law, the tax will be applicable on all undeveloped land, regardless of their use. And the tax will also be applicable on vacant properties. Interestingly, the implementing regulation for white land tax has been introduced on 22nd August 2025. However, the implementing regulation for vacant properties has not been yet been issued. It is expected that this regulation will be issued in the mid of next year, and the provisions of these regulations will be applicable as soon as these will be published in the official gazette. So so the provisions of white tax land has already been introduced, and the provisions have already been come into effect. However, the implementing regulations for vacant property has not yet been issued. Therefore, the provisions are still not applicable. The provisions are going to apply from the next year. Yeah. And then, so we have covered expanded scope. Now coming to the revised fee structure. So previously there was a flat rate of 2.5% on the value of the land. So there was a single tax rate, but now under the amended law, instead of having a flat 2.5% rate, the law has been amended and there's a 4-tiered structure, and there are multiple tax rates that are being applied. So we have got 2.5% on the low priority, and it can go up to 10% depending upon the highly urbanized area. So this was on the white land tax. In terms of the vacant property, the tax can go up to 5%, and this 5% can also increase to 10% depending upon the Council of Ministers recommendation. Then targeted land category. Previously, the law was applicable on different types of land depending upon the number of years, but now the tax will be applicable on the land size of more than 5,000 square meter. Meaning, for example, if as a landowner, if I own a land in Riyadh or any other city, say 2,000 square meter, so the tax will not be applicable on me because I don't hold a land more than 5,000 square meter. So you need to pay tax only when the landowner owns the land for more than 5,000 square meter. Or if there is a common ownership between two persons with a size of more than 5,000 square meter. For example, if Manish and I, we both owns the land, say Manish holds 40% and I owns 60%, and our total ownership is more than 5,000 square meter, then this would also qualify as a taxable land and we both are required to pay tax on our respective portion. Then the amended law also introduced a number of other provisions, such as there is a mandatory registration provision, annual declaration, penalties for non-compliance, empowers the Ministry of Housing to reassess the valuation, etc. So, all in a nutshell, the amended law covers more property types and owners. It encourages development and productive use of the idle land, etc. So there's a significant number of changes that have been introduced uh, in the original legislation, and these are the key amendments. Let's move to the next slide. Yeah. So in a nutshell, these are the amendments that have taken place. Under the previous legislation, as I mentioned before, the tax was only applicable on white lands only. The definition of white land mean any vacant land that is suitable for residential or commercial use only. But now under the amended regulation, the law applies both on white land as well as on vacant properties. Okay. Now, in terms of the tax rate, there was a flat tax rate of 2.5%, but now the tax rate can go up till 10% on the land, and on the vacant property it can go up to 5%, and based on the council's recommendation it can also go up till 10%. So we are going to talk about vacant property in our subsequent discussion. Uh, Now, coming to the various stages and plot size, under the previous legislation, the tax was applicable depending upon the uh, development stage of the land. Like, for example, in stage one, the tax was only applicable on undeveloped land more than 10,000 square meter. And in stage two, it was also applicable on developed land for more than 10,000 square meter. But now, under the amended under the amended law, the tax will be applicable on land or total land with an area of more than 5,000 meters square within the urban boundaries.
And yeah, just to clarify here, the white land tax in the previous regime, so to say, I mean the phases, different phases were implemented in different timelines. So and on based on different cities as well. So there could be a phase one running in Riyadh while a phase two running in Jeddah. So it was a slightly complicated structure, I would say, tracking which phase is applicable in which city, and then what are the kind of land sizes, land parcels, development, non-development status, uh, which was covered in each phases. So now, I think now it has it has made it a slightly simpler approach. With now we know that all land parcels of 5,000 square meters or more within the urban boundaries would be considered for white land taxes. Of course, it has to be a white land first. Yeah,
Yeah,
go on.
that's right. Thank you. And then in terms of the use, as I mentioned before, the land use was only restricted to residential or commercial use only. But now under the amended provision, any developable area within the urban zone will be which are suitable for development would fall within this category. Let's move to the next slide. Yeah. So this was one is important. In my first slide, as I was talking about who all are covered, so any natural person or legal person who owns the land which is subject to tax would fall within the scope of tax. So when a land is subject to tax, so Article 7 of the regulation provides certain condition when a land would qualify as a taxable land. So the first condition is that the land has to be a white land. What do you mean by white land? White land means any vacant land that is suitable for development within the urban boundary, and that is attached to a basic infrastructure such as any road, water, electricity, etc. So the first condition is that the land has to be an undeveloped land which is suitable for any sort of development or construction. The second condition is that the land must be capable of development or construction. The third, it must fall within the scope of application of the fee, meaning the land must fall within the city or the urban boundaries which are announced by the government. So officially what we understand that the government is going to publish or announce the urban boundaries for each of the cities that fall within the scope. So all the cities are not covered. There are specific conditions that are provided in the regulation, and if those conditions are met, then only that city will be announced. For example, some of these conditions are, say, depending upon the mismatch between demand and supply, property prices in a particular city, or if there are percentage of vacant property or vacant land in a particular city, then the government can announce that particular city to fall within the scope. So that was the third condition. So the land has to fall within the taxable city in order to qualify as a white land. The fourth condition is that the size of the land should be more than 5,000 meters square, that we already talked about. And the last condition is that the use of the land must fall within the use case provided by the ministry. So if these five conditions are met, then the land would be considered as a white land, and that would come within the scope of tax. Let's move on to the next one. Yeah. Yeah. So, as I was mentioning earlier, under the old regime, there was a standard flat tax rate of 2.5%, but under the amended provision, there are multiple tax rate starting from 2.5% for a low priority area or the distant area, and it can go up till 10% for a highly urbanized area. So if you have a plot of land in a very highly urbanized area, then the landowner could be required to pay a tax of 10% on the value of the land. And in the midway, we have a medium priority and a high priority zone that are taxable at 5% and 7.5%. Let's move to the next one. Yeah. So this is a tiered structure for Riyadh. So officially, the ministry has come up with a map of Riyadh. However, at this stage, we don't have any official confirmation of the map for other cities such as Jeddah, Al Khobar, Medina, or Makkah. So as of now, only the map of Riyadh has been officially published in the ministry website. So as you can see in this map, so the first tranche, the red patches would be taxable, which are highly urbanized area. That will be taxable at 10%, which is the highest rate. Then we have got 7.5% for the orange part, and then we have got 5% for the green part, and then we have got 2.5% for the blue area, and the green lines that represents the urban boundaries that will fall within the scope of this particular city. So any land which is outside the boundaries will not be taxable, and the land that are within the green patches will be green lines or green boundaries will be taxable. And then interestingly, uh, any area that the any land that is white in color will not be taxable, meaning the tax that will be applied as 0%. However, that area will be counted while computing the total land owned by the landowner. So although the tax rate is 0%, that falls within the urban boundary for the white patches, but it will still be computed while calculating 5,000 meters square. So that's it on
Yeah,
Riyadh.
I think as you can see, I mean, in the map itself, the center areas, the Riyadh city center is 10% all red. As you move out towards the outer side of the city, it kind of the color fades down, you know. So yeah, the central areas are understandably taxable at a higher rate. And the government doesn't want any white lands in the Riyadh city center, and that's how it has structured this tiered kind of map for the city. Yeah.
Yeah, that's right. That's right. Let's move on to the next one. Yeah. So now vacant property. So as I mentioned before, so the new category has been introduced, vacant property. So the vacant property has been defined as a building which are located within the urban boundary and that have not been used for a longer period without any acceptable jurisdiction. So previously, only the landowners were required to pay tax on the land, but now you are required to pay tax on the vacant buildings as well. But as I explained before, the implementing regulation for vacant property has not yet been issued, meaning at this stage, you are not required to pay tax on vacant property. But once the regulation will be out, which is expected to be released in the mid of next year, then As the property owner, you are required to assess whether you hold vacant property, and you would be required to undertake the compliance activities.
Yeah, I think just a couple of points here, Nikhil. I think you might be wondering, right, that the definition is slightly ambiguous. It says properties within the urban areas which have not been used for a long period without justification. Now, what does that long period mean? It could be, is it 6 months, 1 year, 2 years, 3 years? We do expect that there should be some clarification on this. Otherwise, yeah, it is very, very subjective what a long period constitutes. And just having my virtual property owner hat on, I'm just thinking that, look, it might be a good idea for the property owners to just include a clause in their future rent contracts with their lessees that, look, where as and when this vacant property tax comes in, the responsibility is on the tenant, and so that the owner passes on the responsibility from himself to the tenant for paying this 5% vacant prop. Or in fact, if the tenant is there, then there would not be any vacant property at all. So, anyways, I think that was just a random thought. So yeah, we can move ahead.
Yeah, okay. Thank you, Manish. Let's move on to, yeah. So some of the interesting FAQs. So for example, if you owns a particular plot of land, then how do you ensure and what is the way to register your white land? And is there a particular registration deadline announced by the ministry? Yes. The landowner or his representative must register his vacant land on the electronic portal. So there is a period of 6 months within which you need to ensure that you register your land on the portal. Otherwise, there will be an imposition of fines and penalties on you. Okay. So as a landowner, you need to go to the electronic portal, provide some documents such as title deed, evidencing your ownership to the land, and ensure that you do the registration before the deadline. For Riyadh, the registration deadline was 30th October. For other cities, as I mentioned before, the details have not yet been announced yet, but we will closely monitor those and we will let you know. Now, the second one, how can I identify whether my vacant land falls within the scope of vacant land fee? So, as I explained before, the map of each city and the urban boundaries will be announced by the ministry. As of now, the Riyadh map has already been issued and published, and there is a way in the electronic portal you can go and check. However, for other cities, the map has not yet been issued. So if your land falls within the urban boundaries of the targeted city, then yes, you will fall within the scope of the fee. Otherwise, you are exempted or out of scope. Then when the fee invoice will be issued. So once you do the registration and the registration deadline is over, then the ministry will issue you an invoice. It's an annual invoice, meaning if you don't undertake the development or construction activity on the land, the ministry will issue you an invoice on an annual basis, and as the owner you have to pay that tax annually. And as I mentioned before, you have, as an owner, you have got 1 year period to pay that tax. So either you do the construction or completion within a period of 1 year, or you have to pay the tax. The last one, if I own more than one plot of land in one approved area, for example, if I'm the landowner in Riyadh and I own, say, I'm a rich person and I own more than 100 plots of land through a separate deed. So how do I do the registration? Do I need to do the registration separately for all the 100 plots of land, or one registration would be fine? The ministry has clarified that no, you have to do the separate registration for all the plots of land, because you own 100 different title deeds. So you have to perform multiple registration, and single registration would not do. Let's move on to the next one. Yeah. So is there a penalty for failure to register or late payment or violation of the law? Yes. Article 6 of the system says if you violate any of the provisions of the law, if you don't pay the taxes on time, or if there's a delay in registration, then a fine could be imposed on you, not exceeding 100% of your total fee. So penalty could be a maximum of 100% of your liability. Then what happens after I register my land? So for example, if I'm the landowner and if I register my land on the electronic portal. What will happen after that? So once you register your land on the electronic portal, the white land program will study the land, and they will ensure that the land fall within the scope of the legislation, and then they will determine the fee value. So once they determine the fee value, they will issue an invoice to you. The invoice will detail out certain details such as your name, the title deed details, what is the tax rate applicable, what is the tax amount. And if you don't accept the tax rate or valuation, you that the invoice will also detail out uh, the period within which you can raise an objection. And then what happens if there are unregistered land? If you're a landowner and your land falls within the scope of the applicability of the tax, and if you miss the registration deadline, what will happen? So if you don't register your land on time, the program will list unregistered land. They will complete the data on their own, and they will issue an invoice along with the fines on you. So it's similar to best judgments assessment that we have normally seen in other taxation law. So the ministry will perform a best judgments assessment, they will undertake the valuation, and they will issue an invoice to you. So it is important and imperative that all the landowners must ensure that they register their plot of land within the registration deadline. Then which cities are covered? So as I explained before, these are the cities that have already been announced. So we have all the major important cities such as Riyadh, Jeddah, Dammam, Khobar, Makkah, Medina, etc. But only the map of Riyadh has now been officially issued. The map of the other cities have not been officially issued by the ministry as of now.
And
Then
which also means that the date for registration has also not been announced. So what we infer is, and what we expect is that yes, the new system of the tier rate structure will come into effect slightly later for these cities as we go along and in the due course once the announcements are made by the ministry for the registration.
yeah, that's right. Yeah. And then the last one. So if there is more than one owner owning the property, then how are land fees assessed on the owner? So for example, if Manish and I, we both owned a common plot of land, Manish holds say 60% and I hold 40%. So in that case, we both have to pay tax on our respective portion. So this is one clarification that has already been provided by the ministry. So let's move on to the next one.
And then, mind you, just to clarify that these are the FAQs which are not just our brainchild. I would say these are all extracted from the MoMA's website, official website, wherein they have a section on FAQs, and that's where we have gotten all these FAQs from. So these are like official positions of the Ministry of Municipality and Urban Affairs.
Yeah, that's right. Let's move on to the next slide. Yeah. So these are some of the key practical consideration that as a landowner or buyer or seller we need to keep in mind. So if you are a seller of a land and if you wish to sell your vacant property before completing the development, then as a seller you must ensure that you pay all the outstanding fee before you supply the land to your buyer. And as a buyer, it is your responsibility to ensure and you perform a proper due diligence and ensure that the old supplier has already settled the outstanding fee. Otherwise, as a buyer, you would be required to pay the tax. And then if you are acquiring land, as I said, as a buyer, you need to ensure that you perform proper due diligence and ensure you have a proper documentation in place to establish if the land falls within the scope of the applicability of tax or not. So let's move on to the next one. Yeah. So that's it. With this, I conclude my session and my part on white land tax. Manish, would you like to cover some additional things?
Yeah, thank you, Nikhil. Extremely, extremely insightful, and I'm sure participants would have a lot of questions in their mind. And of course, as I said, we cannot cover everything in a 1 hour session. So we've tried to give as much as possible and demystify it as much as possible. But then, yeah, it's natural to have questions. So, Nikhil, what we have is we have some questions from our participants which have come up in the Q&A boxes, right? What I'll do is probably I'll just take up a couple of them, or if time permits, more than two questions. and let's try to answer them on this call so that everyone on this call can benefit from the answers as well.
Sure.
Uh, so Nikhil, the first question I have is, are vacant buildings also included in the white land tax regime? So if I
Okay.
have a vacant building, are they included? Will they be taxable?
Yeah. So I think that's a great question. Thanks for asking that. So as I mentioned before, at this moment, only the implementing regulation for white flat tax land has been introduced. The implementing regulation for vacant properties is expected to be issued in the mid of next year. So therefore, the vacant land fee at this moment would not cover the vacant building. So once the regulation for vacant property would be issued next year, then there would be applicability of tax on this.
Okay, so Mr. X, whomsoever has asked this question, get your property rented as soon as possible, please. Still have the window to do that. Okay, next one is it's an interesting question. If I own a plot in Jeddah, how can I identify whether or not it's subject to tax or not?
Yeah, really, that's a good question. So, as I explained before, the map for each city would be announced on the ministry website. So, officially, as of now, only the map of Riyadh has been issued. So, once the map of Jeddah or any other city would be announced, you need to go and check whether your particular plot of land falls within the urban boundaries of Jeddah. And if it does, then you need to ensure that the other conditions are met and you need to perform the compliance activities. Otherwise, you will be out of scope.
Okay. So essentially that means is we need to, as a landowner, we need to be keeping a very close watch on the Mumra announcements so as to not miss any deadline or so as to be very fully compliant. So it has to be a proactive kind of an approach that needs to be followed.
Yeah.
Okay. Okay. Last question. I mean, I have a few questions as well, and multiple questions, but yeah. Someone has asked about the objection process and which authority is responsible for this process. So, do you want to throw some light on this one?
Yeah, so there are provisions in the implementing regulations in terms of objections and appeal, similar to that we have for other applicable tax legislation in Saudi. So, objection could be submitted to a special committee that would be formed by the decision of the ministry. So, if you're not happy with the valuation or tax rate, or if you're not satisfied whether your land falls within the scope or not, you have the right to objection to the special committee. And then you, as a complainant, you also have an option to go to the administrative court if you're also not satisfied with the objection, or if your objection is rejected.
Okay. Okay. So we have a similar process for appeals and objection as we have for tax laws then. Okay.
Yeah. Yes.
Um, Another question, I think we can take at least two more questions looking at the time. So an invoice was issued for the current year and paid, someone has asked. And after the payment, the land was developed. Now his question is, can I get a refund for the tax that I paid?
Yes. Yes. So I think that's a quite interesting one. So there is a specific provision in the law that clarifies that if an invoice has been issued and the land was developed or constructed within the same year, then the owner has an option to claim refund. So the process is that the owner has to go to the electronic portal. They have to submit a request to cancel the invoice that has already been generated, provide certain documents such as completion certificate or planning approval showing the completion or development has already been completed, and subject to the review of the application, the owner would be entitled to claim the refund of the taxes that has already been paid.
Okay, okay. So why if the tax is paid and if you complete the development within, is there time within 1 year or something?
Within the same year.
Yeah, within the same year, then you can get a refund of that. Wow, interesting. Wow, I'm loving the questions which are coming up. Last one. Someone has asked, look, I have 3,000 square meters of land in Riyadh and 4,000 in Jeddah. So total is 7,000. Will right line tax apply on me?
Yeah, okay, so the last one is quite a good one, I would say. So you need to see the applicability city wise. So as a landowner, if you own one plot of land in Riyadh and another plot of land in Jeddah, and the size of the land is less than 5,000, then the law doesn't apply on you. You will be out of scope because you need to see 5,000 limit per city wise.
Okay, okay. So yeah, at least so far, a good news that you won't be subject with your current holdings in each city. You won't be subject to any whiteland tax, Mr. Y, in that case. So okay, I think we're pretty much there. I think just 4 minutes to 12. Um, we are done with our sessions. So I would like to thank everyone who has joined in for this session, and we hope that you find this session extremely insightful. I thank my organizing committee, our IT team, our branding team, Nikhil, and my entire team who has helped us put together the slides, to put together the entire IT infrastructure together. And of course, thank you for all of those who have joined us. On that note, we give 3 minutes of your life back. We wish you a happy weekend for those who are in Saudi Arabia, and a happy Friday for those who are outside Saudi Arabia. So on that note, thank you so much. And if you need any clarifications, you know whom to reach out to. Thank you.
Yeah. Thanks, everyone. Thanks for joining.